I never assaulted.
Stop. Now's not the time. I'm just trying to tell you.
She's threatening to get a knife. She's bigger and stronger than my client.
What's she on probation for?
Trying to stab her older sister, my other daughter.
And that's intense.
What you just saw in that brief clip wasn't chaos for entertainment. It was a mother's future hanging in the balance. Judge Fleer can be heard ordering everyone to stop. A defense attorney urgently yells about a knife, but that moment alone doesn't explain what's really going on. At the center of this case is Samantha Walker, who is staring down the possibility of 12 months behind bars and a $4,000 penalty after being accused of attacking her 15-year-old daughter. From a surface-level view, the situation seems straightforward, with Samantha identified as the main offender in a domestic incident. Yet once you look closer, the narrative starts to unravel. How does someone labeled as the victim already have a record for trying to stab her own sister? And why did a piece of video evidence, initially presented as proof of Samantha's wrongdoing, later become the key reason she could walk away without consequences? If you want to see how courtroom facts can flip a case upside down when first impressions are misleading, make sure to subscribe for detailed legal breakdowns like this one. Now, let's rewind to where this story actually started.
Walker. Ms. Walker, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge.
Okay.
On November 4th, 2024, an officer was dispatched to a family disturbance call at a residence in Harris County, Texas. The complainant, a 15-year-old, stated that the defendant, her mother, assaulted her after they got into a verbal argument. The complainant stated the defendant displayed verbally aggressive behavior towards her, grabbed a hold of the complainant's left wrist, and said, "If you come near me, I'll beat your ass," and began to engage in a physical altercation with the complainant. The complainant stated the defendant, using both open hands, placed the complainant in a headlock and the complainant felt pain. Both law enforcement and CPS records indicate a history of physical altercations and verbal altercations between the complainant and the defendant, and the officer observed video footage showing the defendant acting as the primary aggressor towards the complainant and observed a minor injury cut on the complainant's left arm.
So we have prior violence, any prior charges?
There's no prior
Any,
charge.
no
Your Honor.
prior injury to a child, felony charges?
No, Your Honor.
Child means 14 years or younger.
She's 15.
Okay, ma'am, I'm going to find that there's probable cause to go forward with your case.
No, Your Honor.
Don't. Now's not the time, ma'am. You have the right to remain silent. Exercise that right. I've got a bunch of DAs here. Anything you say, they're going to use it against you. Guys, what do we do about contact? You know? Yeah, well, so Michael, I need your help. You know, this is a 15-year-old child. We have a history of violence allegedly between mom and daughter.
Yes, Judge.
Now we have an assault case against a 15-year-old. And according to what Alex says, there's a history of it. It's unacceptable.
Judge.
Do you have a lawyer, ma'am?
I'll be retaining the lawyer, but there's no history of violence between us.
You're calling for a Walker?
Yes.
Which Walker?
Walker. It's in custody. Oh, thank you.
Okay.
So, what my plan was, and I already spoke to my people about this, is we were going to check the offense report to see where the child was taken. Were they taken to CPS custody, state custody? Was there some other guardian? Once we're aware of where the child is, we are going to be asking for a no contact order to be granted based off of the allegations of a history of
What about
violence.
now? Is there something that we can do now as far as finding out where the child is?
Well,
you know?
we're going to call CPS today and see if they're in state custody. The offense report also might indicate where it is. If not, we can call the officer and they should know.
Yeah, I'd like to, because I think it's serious. I mean, if we have a history of violence, I don't want that to happen anymore.
There's no.
I know that you're telling me no, but I have other people that are telling me differently.
I've never.
Okay, well, ma'am, don't. Now's not the time. But my primary concern is the protection of every single person in Harris County, bar none. That's it. Especially if it's a child. And
I'm not a threat to my child, I promise you.
you are now charged with assault, ma'am, on that 15-year-old child.
I never assault.
Stop. Now's not the time. I'm just trying to tell you, if I find that there is a history of violence with the child, I'm going to order you not to have contact with this child.
I understand,
As it stands now,
but I promise there's no
I'm
history
entering
of
in called a
violence.
magistrate's order for emergency protection that identifies EJ as a protected individual. You
I
cannot,
have to take her to appointments and stuff like that.
please listen. Okay, I know that you're trying to think of stuff to say,
No,
but
I'm
I
being
want you to
honest.
listen because this is very important stuff. And if you don't hear it correctly, you do something to violate this court order, they're going to file additional charges against you. I'm entering in an order for protection for that 15-year-old child. She's now a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Detention Penal Code, which is the stalking